Did you know that even if you already have a living trust, your assets could still end up in probate court? This is one of the biggest estate planning mistakes I see, and it happens more often than you think. Hi, I'm Anila Rasul, owner and lead attorney at ASR Law Firm here in Boca Raton, Florida, where we help our family, business owner, and real estate investor clients protect what matters most through strategic estate planning. Today, I want to quickly explain how to fund your living trust because having the document alone isn't enough. So, what does it mean by funding? Think of your revocable living trust as an empty box. It's beautifully designed to hold your assets, but until you actually place those assets inside, it can't do its job. Funding your trust simply means transferring ownership of your assets like real estate, bank accounts, investments into the name of the trust. If you skip the step, those assets may still have to go through probate, defeating the entire purpose of creating your trust in the first place. Why funding matters. When your trust is properly funded, it lets your loved ones avoid probate, it keeps your estate private, and it ensures your chosen successor trustees can manage everything seamlessly if something were ever to happen to you. It's one of the simplest ways to make sure that your planning actually works the way that you intended. So how do we fund your trust? Here's how it works in Florida. Usually we start with folks' real estate property. You'll need a new deed transferring ownership from you individually to your trust. That deed then gets recorded in the county records. Next, financial accounts. Contact your bank, your financial advisor, and ask to retitle your checkings, your savings, your brokerage accounts into the name of your trust, or to list your trust as the beneficiary of these accounts. Then update beneficiary designations for life insurance or retirement accounts. You might not need to retitle these assets, but you can name the trust as either a primary or contingent beneficiary. Finally, keep records. Store copies of every deed, assignment, or letter showing which assets are inside of the trust. And whenever you buy something new, a property, a vehicle, or even open a new account, remember to title it correctly or assign it to your trust. Now, here's where some people get tripped up. They sign the trust and they think it's done. But if assets remain in their personal names, they still go through probate. Don't let your plan stop at the paperwork. Make sure it's funded and ready to achieve your goals. At ASR Law Firm, we regularly guide clients across Florida through every single step, from drafting your trust to transferring your assets and keeping your plan up to date on a yearly basis. If you found this information helpful, please like, share, and tag someone who might also find it helpful. And for those of you who already have a trust and might be unsure whether it's properly funded, or if you're just getting started and need some guidance, please feel free to reach out to us and schedule a complimentary consultation directly on our website. We're so happy to help.